I definitely shouldn't have used, obviously. That's one of my biggest mistakes, which sent me on a huge spiral.
Okay, so this is in the matter of the people of the state of Michigan versus Cody Joseph Lowe. Mr. Noe had requested a bench conference. I did take an opportunity. We called Ms. Teskey back and we had a conversation with Ms. Teskey. Mr. Noe, you received the probation violation recommendation report.
I certainly did.
All right, and you've had time to review that with Mr. Lowe.
This morning we had a few minutes, yes.
All right, so Mr. Lowe, you've had an opportunity to read and review the recommendation.
Yes, Your Honor.
Okay, and you've had ample time to talk to your attorney?
Yes, Your Honor.
Okay. Are you satisfied with Mr. Noe and the advice that he's given you?
Yes, Your Honor.
Mr. Noe, do you wish to explain or challenge the accuracy or relevancy of any information in the probation violation report?
No, Your Honor, just a brief statement for myself and my client before sentencing.
All right. So, is there anything you'd like to say on behalf of Mr. Lowe?
Thank you, Judge.
Welcome back to Sovereign Verdict. Today we're diving into the case of Cody Joseph Lowe. Cody faced probation violations in Michigan after completing boot camp and the drug court program. His violations were mostly technical: substance use, crossing state lines, and failing treatment compliance, not new crimes. Let's dive back in.
Thank you. There is some things I want to say on behalf of Mr. Lowe. Hopefully I'll be as quick as possible, Judge, but there's quite a few things I want to say. Judge, I want to bring up first off and foremost that we're acknowledging the seriousness of Mr. Lowe's third violation. He knows he's been given chances, probation, drug court, treatment, and as he stands here today, he owns the failures that he's had with those things. But the question before the court, I think it's important to note, because I think the Department of Corrections is recommending the prison sentence, is what that consequence should be. There absolutely should be. I won't argue with that. The question is whether that consequence would be proportional and what consequence actually promotes rehabilitation instead of setting my client back months, if not longer, in his rehabilitation process. Judge, we are asking for a 1-year sentence. I know the court is not inclined to grant that, but we are asking the court for leniency. We are asking the court that fits the violation, fits the guidelines, and ultimately fits the reality of Mr. Lowe's situation. First off and foremost, I want to bring to the court's attention that all these violations are technical, not new crimes. These are new crimes my client had been convicted of. Ultimately, I think that I'd be having a much different tune this morning. There's been no assault. There's been no threats. There's been no weapons, no violence, no criminal behavior other than, unfortunately, my client's battle that he's had with addiction. I think that you have to draw a line here between a criminal reoffense and a relapse-based non-compliance, which I think we have here. And an appropriate response here is a structured local sanction that's not a multi-year Department of Corrections sentence. My client's already served a meaningful amount of time. He's been in jail since October 1st. He has been obviously went through a time as the jail indicated sort of detox, but my client was on methadone, so it's off that, so that's what he had to detox off of. He's had long sustained periods of sobriety and stability. He's receiving his prescribed medications, a blood pressure medication. He ultimately has been truthful and cooperative following these violations. Jail is working. My client is making meaningful change. Department of Corrections is not needed in this matter. Obviously, for the assault file, the guideline minimum is 0 to 17. 1-year jail sentence would fit squarely within that. For the drug file, that is ultimately a 29 to 57 month calculation. Obviously, I was not his attorney at the time those were calculated. But the conduct underlying the violation here does not justify some sort of prison term. These are relapses. These are substance use violations. Judge, if the court really wants to consider, one of the things the court has to consider here is obviously punishment, which we're certainly acknowledging, but ultimately one of the goals here is rehabilitation. My client has a fiance, he has stable housing, he has a legitimate business, he owns and operates, his family supports him. A years-long prison term is going to destroy that employment. It's going to sever his support network and eliminate his recovery momentum. While a jail term would not do all those things. The court's goal with Mr. Lowe, to its credit, to its great credit, has always been rehabilitation of Mr. Lowe. The court has worked for a significant amount of time, Mr. Lowe, longer than I have, in fact. The court gave him a downward departure before the court because he could change. And frankly, that opportunity, you'll rightly say, he has taken that seriously until he had a relapse. Jail has been obviously a wake-up call for him. He went through a very rough time, though, especially when he was first incarcerated. Again, he's not asking for probation right now. He's not asking for just time served. That would be, I know that's wildly unrealistic. I know it's not possible. I know it's not what the court's looking at. But ultimately, he is asking for a meaningful sanction. Judge, looking at a jail term or a significantly shortened with the Department of Corrections term does fulfill all the goals of this court. He'll have a punishment. He's spent in jail since for almost 2 months on this incident violation.
Cody's lawyer argued for leniency, highlighting his progress, stable housing, supportive family, and legitimate business. A full prison sentence would disrupt his rehabilitation, they said. Cody has shown accountability, cooperation, and history of long-term sobriety. Let's dive back in to see what happened next.
He has no deterrence. He has no desire ever to go back. Again, I know the court didn't talk to him. I did, and I can tell you right now, especially when he first went in regarding coming off that methadone, it was rough. It was really, really, really bad. I spoke to the jail sergeants. It was bad. It was really bad. I spoke to him on the Zoom. It was bad. Obviously, jail has forced the clarity that my client needs in sobriety. And in terms of ensuring public safety, there's been on these violations no new assaultive crime, no new crimes he's been convicted of, none of that. So, Judge, for all these reasons, we are asking the court to impose a county jail sentence. I did calculate the credit of my client. The Department of Corrections, obviously.
Yeah, I'm on Zoom.
Mr. Sneed, go ahead and mute yourself, please. Thank you.
The Department of Corrections did calculate that credit. That's correct. My client does concur with that. Judge, this is a serious sentence, but it needs to be a fair sentence. And a sentence that gives Mr. Lowe accountability while preserving the possibility of a long-term rehabilitation, which I think, if my client had committed some sort of violent offense or something like that, again, I'd be seeing wildly different too. That's not the case here. So I think the Department of Corrections, I think the recommendation, while they are recommending their guidelines, I don't think is appropriate given that these are obviously technical violations, and that ultimately, I think that my client again would benefit from the sentence I recommended, and ultimately, I think that my client does want to say some things. I think he wants to take some. I know usually, my clients I don't want them to say anything for obvious reasons. But in this, I think my client my client wants to come forward and take some responsibility and tell the court his own words. So if you can get that opportunity this morning.
Mr. Lowe, is there anything you want to say on your own behalf before the court passes the sentence?
Yes, Your Honor. First, I want to take accountability. So I shouldn't have not reported to Sarah. Definitely shouldn't have crossed state lines. And I definitely shouldn't have used, obviously. That's one of my biggest mistakes, which sent me on a huge spiral. When Sarah called me and gave me the courtesy call she gave me that a warrant was coming out, it was just all downhill from there immediately afterwards. Though I started that by crossing state lines, I do take full accountability for that. I do want to thank you for giving me drug court. I appreciate that because it gave me like just huge growth in my life while I was on drug court. I wish that when I went to rehab, I would have had more time there because I was only there for 11 days before they completed me. So I feel like if I had more time, I maybe would have done better.
Mr. Sneed, you're standing.
Yes, Judge. Not many cases do we have the probation department request a prosecutor at a sentencing. This is an exception here. Ms. Teskey reached out, is requesting the people to appear, requesting the court to adopt the recommendation by the
Cody spoke for himself, admitting his mistakes, including substance use and not reporting to authorities. He took full accountability, thanked the court for drug court opportunities, and reflected on how relapses derailed his progress. Let's dive back in to hear the judge's response.
probation department. And if the court would like to hear from Ms. Teskey, I think she's prepared to state the reasons why.
Ms. Teskey, is there, Ms. Teskey, I call you only as you were one of the team leaders in the probation department for the recovery court program, which Mr. Lowe was in. So of course, is there anything you wish to add to your recommendation?
No, Your Honor. I rest on the comments I made in the bench conference.
Now, you did attach to your pre-sentence report the photographs from the victim in the assault case. Is that correct?
That is correct.
All right.
I don't have those.
We're going to hand that down to you. I don't know if that was just part of the file and she attached it.
I don't know why I would not be provided that.
Well, it was part of the original PSI, so it's attached to the original
reference.
PSI that's always put in my file. Mr. C. Yeah. Oh, Mr. C would like to see them as
I
well.
wasn't in the bench conference.
I have had a chance to review that. It's the first time I've had a chance to review that or know that was part of the sentencing, so I can respond to that briefly.
Well, that was part of the PSI. I just wanted you to know
Certainly,
that they were here.
certainly.
Okay.
And I've had a chance to review those, and ultimately, I understand those are severe, and I understand just seeing this first time, obviously that's severe. But that being said, that was taken into consideration at the initial sentencing. I don't know if the court's inclined to use that as a reason or enhancement.
No,
Okay.
I'm just letting you know that they were there.
And that's fine. I just wanted to clarify that hopefully that was used in in the initial sentence. Again, that we were just on these violations, not on new conduct or something like that. I certainly get that. Matter of fact, I think those help my client because that show, yes, he certainly did looks like very horrendous thing. He ultimately took responsibility for it. That's not what we're here for today.
Okay. All right. So when we were initially here for sentencing way back on March 1 of 2024, the initial recommendation from the probation department on file number 21-20527FH was for an MDO sentence of 1 year to 1 year, 11 months to 10 years. And that would be for the assault with intent to commit great bodily harm. And then on 23-21347FC, the recommendation at that time was for a sentence of 29 months to 20 years with the Michigan Department of Corrections. You have excellent counsel representing you today. Mr. Noy was very eloquent today. You as well, Mr. Snake. But Mr. Noy was very prepared and very eloquent and did talk about the advancements you've made, but also understanding that there have been some concerns. So the initial sentence is now the same recommendation as for today. At the initial sentence, there was a downward departure as part of a plea offer that was made. You served 1 year in jail. We did release you to boot camp. You successfully completed boot camp. Then you were ordered to enter and complete the drug court program and placed on probation for a period of 3 years. We're here today because while you did successfully complete the boot camp program and by all appearances, you were doing really well in the recovery court program, but you really weren't. You were abusing, you were hiding, you were forging documents for treatment classes, and you left the state. And you initially lied about what happened when you left the state. So it's almost been like you're taking advantage of the recovery court, you're getting what you need from it, but you were living this double life the whole time. Your support system is there now and will always be there. You are loved by your family, by your fiance. You work really hard. You have the ability to be successful, which is why you got the deal you got, right? And, you know, we all like you. We've all enjoyed working with you, but, you know, at the same time, I feel like to some extent you were playing a game with us. Like you thought you were smarter than us. And here's the deal. Everybody gets caught. You always get caught, whether you're my kid, Mr. Seed's kid, Mr. Noe's kids. They're not old enough to cause trouble yet, but they will. And then even you, and you know, and you have your dad to look to because you saw what he went through and what it took for him to get where he is today, right? And you got to fix that because at some point you're going to be a dad too, right? Mr. Glazier, could you mute your device, please?
Sorry about that.
Okay. You know, so the victim at the initial sentencing, I believe, wanted I think he wanted more of a sentence than plea agreement that was worked out. So I can't downward depart again, but I will take into account what you have done. I wish I could send you to boot camp. I wish there were other options left, but you've burned through them. So, it's a sentence of the court that on file number 21-20527FH. Has he paid his fines and costs off, Ms. Teskey, on all these files?
No, Your Honor, he owes significant restitution on that assault case.
Yeah, I know. Okay.
My client has paid some fines and costs.
Yeah, he's paid. He's been paying
Paid
this
some.
recovery work.
This has to answer the question. I want to question.
All right. So on file number 21-20527FH, let me get to the right. 20527FH, sentence the court, you'll serve 17 months to 120 months with credit for 178 days. On file number 23-21347FH, that's one where your guidelines, there was a downward departure. It's a sentence of the court that you will serve 23 to 240 months with the Michigan Department of Corrections and will give you credit for 178 days. I'm giving you some credit for the work that you've done, but Mr. Lowe, there are services available through MDOC. I'm going to order that he enter, you know, any programming that would be appropriate for him. Mr. Lowe, your family and your support system will be here when you get out. Your work will be here when you get out. You've done it before. You look worse than I've ever seen you. You know, you have circles under your eyes and you look sick just sick about all of this. And I don't blame you, but I want good things for you, but my hands are kind of tied in this situation because of the guidelines. And so I want you to succeed and I want you to get out and I want you to do better. No more of this. Don't be 55 like your dad when you finally get it. Okay? I don't know how old your dad is. So if he's mad, I've said he's older than he is. I apologize. So my bailiff's going to hand down to your notice of right to appellate review. There's one for each file. I want you to initial and date your each copy on the top. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days.
Welcome back. The judge acknowledged Cody's remorse and prior achievements, but stressed his violations showed dishonesty and non-compliance. Cody was sentenced to 17 to 120 months and 23 to 240 months with credit for time served, with orders to join MDOC programs. Let's dive back in to see what this means for his future.